questions against the professional game match topic?
Yes.
My Lords, my Ladyship, I propose to adopt the following structure in respect of my submissions. First, to deal with mutuality of obligations, to deal with that by reference to first the relevant authorities, what we say are the FTT's errors of law, and then finally an issue that came up yesterday, FTT paragraph 174, and what does it mean? Second, to deal with control, and again, to start with the relevant authorities, and then to identify what we say again are the FTT's errors of law in respect of its approach and conclusions on control. My Lords, my Lady, our printed case, I won't take you through our printed case, but I do say that the appellant has failed to engage with many of the points set out in our printed case, which responded to their printed case, and which are derived from the authorities. Many of those authorities not gone to. Can I then start with mutuality of obligation and the authorities? I know you were taken to it yesterday, but I just would like to start, please, with ready-mix concrete at page 2. The ready-mix concrete is at 266, but the relevant passage is obviously at 284. But again, can I just give you some context on ready-mix concrete? Because, of course, ready-mix concrete was not an overarching contract case. It wasn't an employment rights case at all. It was, in fact, a national insurance case. National insurance case concerning whether concrete delivery drivers were engaged under a contract of service and therefore employed persons for national insurance contributions purposes. And of course, that's the same as in this case, our case. So when you read the guidance in ready-mix concrete, I say it is relevant that it is being given in that context. It is obviously not addressing the very different problem of employment rights which require a qualifying period and looking at what is the necessary mutuality of obligation in that overarching contract type case. If I could ask you then to just go to 284C. A contract of service exists if these three conditions are fulfilled. The servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. And then Ms. Justice McKenna at E explains, says he'll say a little bit more about that. There must be a wage or other remuneration, otherwise there will be no consideration, and without consideration, no contract of any kind. That's the first point, looking at consideration and the existence of a contract. Second, the servant must be obliged to provide his own work and skill. Freedom to do a job either by one's own hands or by another's is inconsistent with a contract of service, though a limited or occasional power of delegation may not be. And that's the second part of the first limb, mutuality of obligation, and an important part in many cases. Examples are Pimlico plumbers, Weight Watchers, where they were construing the relevant clause in Weight Watchers was a substitution clause. And of course, so my Lord's Ladyship already have the point that RMC Lim 1 is not the only test. It's simply a gateway to the second and third tests. But also, it is not the empty vessel that my learned friend suggests. It serves a real and effective function. An example in respect of the contract and the employer's obligation, the obligation to pay the wage, Quashi is a good example of how that applies. Because, of course, in Quashie, as identified by Lord Leggett in Uber, the ET found that there was a contract between the dancer and the club. But, critically, under that contract, the club did not have any obligation to pay the dancer. So that fundamental obligation on the part of the engager to pay a wage, or to pay, was absent. Critically, though, actually the obligation to pay went the other way. It was the dancer who was obliged to pay the club for the opportunity to dance at their premises, and that's why it was a contract of license. My Lords, my Ladyship, can I then turn to McMeechan, please, which is 177 of the... Sorry, that's a wrong reference. So it starts at 409. Court of Appeal, and worth just having a look, it's Court of Appeal in 1996. And you'll see the Court of Appeal judgment is given by Lord Justice Waite. It's at page 411. I won't go through the facts in great detail because obviously my learned friend took you to some parts of this judgment. But the individual was engaged by an agency to work for the end user, and the individual claimed he was employed by the agency and sought unpaid wages. So critically, not an unfair dismissal case. So again, not concerned with a qualifying period. Concerned with was the single short engagement in respect of which he is claiming the unpaid wages, was he an employee of the agency? Could I ask you then to go to page... So I've managed to confuse myself by using both the electronic references but also the internal page references on the report. But if I could just go to 411C, please. That's where you get what the case is about. And then at E, you'll see that the claimant advanced an overarching contract claim before the ET and the EAT, and that the Court of Appeal permitted him to argue the alternative single engagement basis, namely that he was entitled to be treated as an employee of the agency in respect of the single stint served with the particular client in respect of whom the monies claimed had been earned. You'll then see at 412H, and again, just trying to orientate ourselves when we come to look at the contract.
These are the conditions that we were referred to yesterday.
Yes, yeah. But just before that, though, do you see above that, the paragraph I want to take you just above that, do you see it defines who the contractor is? And you'll see that it is the agency, Knoll Employment Limited. So where we see references to the contractor in the terms, that's to the agency with whom Mr. McMeechan was seeking to establish a contract of employment. And my Lord is right that he was taken, or that your Lordships and Ladyship was taken to the conditions, but what you weren't taken to was condition 10, which you'll find at the top of page 414A. Because, as we set out in our printed case, in fact, McMeechan is a case involving a right to terminate at will, a point you weren't addressed on yesterday. So when you are reading McMeechan and what McMeechan says is the requisite mutuality of obligation in an individual contract case, it is relevant that those observations are made in the context of a case involving a right to terminate at will. And you'll see how the Court of Appeal, what the relevance the Court of Appeal say that has. You then at 413 to 4, so we've looked at those are the conditions. Could I then ask you to go to page 415? At 415 at H, so F to H, I don't think this was a passage you were taken to. And this is under the heading of the law, which is one of the reasons why I'm taking you to it. So the heading of the law is at D, 415. And you'll see at F, it talks about the empiricism of that approach does not preclude recourse to familiar touchstones which have been found useful over the years. Harvey, on industrial relations and employment law, gives a useful summary of them at paragraphs A10 to A53. I do not need in this judgment to mention more than one of them. It is usually referred to as the criterion of mutual obligation. The principle which it enshrines is that if there be an absence on the one side of any obligation to provide work and an absence on the other side of any obligation to do such work as may voluntarily be provided, then that provides a powerful pointer against the contract, assuming that in such circumstances any contract has arisen at all, being one of service. Temporary or casual workers pose a particular problem of their own, in that, in their case, there will frequently be two engagements, to use a neutral term, which the tribunal may be called upon to analyse. There is the general engagement on the one hand, under which sporadic tasks are performed by the one party at the behest of the other, and the specific engagement on the other hand, which begins and ends with the performance of any one task. Each engagement is capable, according to its context, of giving rise to a contract of employment, and it says that that's acknowledged in Nethermere. Then do you see it talks about the general engagement? This is the type of arrangement most frequently found in the authorities. The reason, no doubt, is that the temporary workers' single stints will seldom have been of sufficient length to found an independent claim in their own right for redundancy or unfair dismissal. And you see he cites the Nethermere case as an example of that. And of course, that's the case relied upon by my learned friend. It's an overarching contract case. And so the observations of the Court of Appeal in that case have to be considered in that context. They are looking at, is there a contract that subsists over the qualifying period? At one point, the qualifying period was 1 year, now 2 years. Then do you see at the end of that paragraph, those cases also illustrate how the course of dealing relied on for that purpose may in some cases involve a series of single engagements to which the law will, in some instances but not in others, attribute independent contractual effect. And of course, the same is true of the other cases relied upon by my learned friend in his printed case. He only took you to one of them in addition to Nethermere yesterday, which was Carmichael. And he referred you to Carmichael in support of the proposition that the Lim 1 mutuality of obligation requirement involves a requirement to offer and accept work. But the first point is that Carmichael, like Nethermere, was an overarching contract case, but also the House of Lords, both Lord Irvine and Lord Hoffman, specifically identify and raise the fact that the position would be different in respect of the individual engagements upon which, when in that case it was tour guides of an electricity power site, that they attended, that they undertook. And, my lords, can I just give you a paragraph reference, my lady, in our printed case? I don't ask you to turn it up, but you'll see in paragraph 30, we address each of those overarching contract cases relied upon by my learned friend, and identify the paragraphs in those judgments where either the Court of Appeal or the House of Lords expressly recognise that they are not dealing with individual contracts, but dealing with overarching contracts. Indeed, in the Oxford case, Clark and Oxford, relied upon by my learned friends, that recognition goes so far as to remit the case back to the ET to determine the individual contract, the status of the individual contract. As I say, all dealt with in detail in paragraph 30 of our printed case. So I don't propose, and it's for that reason that I don't, not addressed yesterday, so I don't propose to take up time today taking you to all those paragraphs to point that out. But you'll see that's also what the Court of Appeal applied and took into account. Can I then please refer you to page 422H, which my learned friend did take you to. Just to contextualise what then follows. You'll see the argument, I think it's at E to H, that advanced by Lord Meston. So when the Court of Appeal raised with Lord Meston on his feet that they'd like him to address the individual contract that had not been raised before, he raised three objections. The first, that the specific engagement cannot, as a matter of law, be severed in the way that is proposed from the general engagement. Two, G, even if one is not a proposition applicable to all cases, it must apply to a case like the present, where the conditions govern both the general and the specific engagement. And then at H, at 3, it was expressly argued that the absences of mutual obligations to provide work or do work still relevant, and in fact fatally so, for the purposes of construing the terms applicable to the individual contract. And you will see that the Court of Appeal at 423G reject all of those arguments. And as I said at the outset, when reading all of these points, particularly relevant in our case, is the fact that that this was a case in which there was a right to terminate at will. So all of these observations are made to that case, to a case involving the right to terminate at will. And I say what's important here is that the contract of employment that was seeking to be established was not, as in some other cases, as between the individual and the end user. I think it was a catering company, Sutcliffe. It was between the individual and the agency with whom he did have a contract, and the terms we've seen. And that contract gave the agency an unfettered right to terminate at will at any point. And as I'll show you, when you look at these cases on the right to terminate at will, actually, insofar as there is a right to terminate in our case, it's less unfettered than in those cases, because in those cases, in our case, it's accepted that once the referee does arrive, neither party, that you can't pull out. I'll come back to neither party when I come to address the facts, because your Lordships raised some interesting points yesterday about what about, if it came to their attention that there was something that impacted on impartiality. So I'll come back to that later. But my point is that when you look at McMeechan and when we come on to Stevenson and Drake, in those cases, having started the engagement, either party could walk off. So in the middle of performance. Now, so when we look at 423G, what the Court of Appeal say is this. Lord Meston's fundamental submission that no claim to a single stint employment status as being the temporary worker and the contractor's maintainment in law has already been stated. I would reject it for the following reasons. In a case like the present, where the money claimed is related to a single stint served for one individual client, it is logical to relate the claim to employment status to the particular job of work in respect of which payment is being sought. He then cites Harvey again, and this is important. The better view is not whether the casual worker is obliged to turn up for or do the work, but rather if he turns up for and does the work, whether he does so under a contract of services or for services. That's relevant when we come to look at the FTT's reasoning in our case, because of course they don't focus on that question, they focus on the prior question. And I'll address you on why I say they've got that wrong in terms of their analysis of the obligations pre-match day. But in any event, that's a complete answer to the point. The question is not whether he's obliged to turn up for or do the work, he or she, but rather if he turns up for and does the work, whether he does so under a contract of services or for services. Then this at 2, there is nothing inherently repugnant, whether to good relations in the workplace or in the law, about a state of affairs under which, in an employment agency case, the status of employee of the agency is allocated to a temporary worker in respect of each assignment actually worked, notwithstanding the same worker may not be entitled to employment status under his general terms of engagement. In O'Kelly, the Industrial Tribunal reached fortuitously a decision that both the general and the specific engagement failed to give rise to a contract of service. The importance, however, of the case is that the tribunal did give independent consideration to both heads of engagement and was held to have been right to do so. Then at 3, in addressing the second argument, talking about the fusion of the overarching and an individual contract, at C it says, the only result of that fusion is that the same condition will have to be interpreted from a different perspective according to whether they are being considered in the context of the general engagement or in the context of a single engagement. That does not make the task of the tribunals any easier and is liable to lead to the unsatisfactory consequence that the same condition may need to be given a different significance in the one context from that accorded to it in the other. Importantly, those disadvantages do not, however, supply any valid reason for denying the temporary worker or the contractor the right to have the issue of contractual status judged separately in the two contexts. And so, yes, it's right that the ready-mix concrete has the same three-stage test, but what the Court of Appeal are there acknowledging is that there are differences when you're applying it to an overarching and an individual contract. And of course, that basic difference that the courts have recognised for over 30 years is the difference that Malone & Friends' entire primary argument is based on, because their argument, accepted by the upper tribunal, is that the same approach applies to both overarching and individual contracts. I'll come on, Malone, to show you when we get to it, because they say that just as in an overarching contract, in an individual contract, you need an obligation to accept work and also an obligation to pay in lieu, to offer or pay in lieu. And that is exactly the arguments that are advanced by Lord Meston and rejected, and then repeatedly rejected in the cases that follow. Can I then ask you please to go to 425C. Sorry, can I just, before I do that, 424H, just again, it just makes clear. So it's there talking about the single engagement claim. The issue is whether the individual assignment worked by the applicant for Sutcliffe Caterers for a period of 4 days during January 1992, in respect of which he claims his unpaid remuneration, did or did not amount to a contract of service in its own right. And as I say, what's clear, as I've already shown you, is the contract of service is not with Sutcliffe, the end user, it's with the agency. Then this talks about the terms, says those must, however, be construed according to the context afforded by a specific as opposed to general engagement. That's at B. That requires them to be interpreted in my judgment as follows. And then do you see at 2, this is between C and D, the Court of Appeal addressed the clauses relied upon by Malone & Friend yesterday, 3, 6 and 9. the conditions, 1 has already dealt with 5. 2, the conditions 3, 6 and 9 and the first sentence of 5, excluding mutuality of obligation, are irrelevant in this context, that context being the specific engagement. That is not to say that in a different context of a general engagement they would be without effect. They might even turn out to be of crucial, even decisive importance. In the circumstances of a specific engagement, however, there is nothing on which they can operate. When it comes to considering the terms of an individual, self-contained engagement, the fact that the parties are not obliged in future to offer or to accept another engagement with the same or a different client must be neither here nor there. And then, do you see 3? Weighing the conditions in the way that the law requires, there is to be set on the one sense. So, just pausing here, we are now at the stage 3 balancing exercise. And you'll see this is where the judge brings in, the Lord Justice Waite brings in the unilateral right to terminate, the right to terminate at will. So not at the mutuality stage, it's irrelevant to mutuality of obligation. It's at the third balancing stage. He says, weighing the conditions in the way that the law requires, there is to be set on the one side, contract for services, the express statement that the worker is to be regarded as self-employed and not to be working under a contract of service, and the liberty reserved to the worker of being able to work on a self-employed basis for a particular client. On the other side, and so this is where they take into account the right to terminate at will, on the other side, contract of service, are to be set the reservation of power of dismissal for misconduct, so the fact that the employer can discipline, the power of the contractor, and we know that the contractor here is the agency, because I've shown you that's what the defined term, the power of the contractor to bring any assignment to an end, the provision of a review procedure if termination takes place, etc. So, actually, the engager's right to terminate at will, not only is it irrelevant to the Lim 1 requirement of mutuality of obligation, insofar as it may be relevant at stage 3, it goes the other way. And why? Is my Lord Legate's point yesterday about subordination. When you're looking at where the power lies, where the sort of the dependency lies, that's where it goes. Now, of course, if it's there on both sides, they cancel each other out. But of course, you don't have... So, I'll come on to address you when we get to... But there's no suggestion that that's this FDT's analysis, because the FDT deal with it as part of mutuality of obligation, to which it is simply irrelevant. As I'll show you, it's articulated in more clearer terms by Mr. Justice Elias in the next authority I'll take you to, where he develops this and articulates it, again, in a case where there are both going either way, rights to terminate. But can I just say this before I leave McMeechan? In terms of mutuality of obligation and the fact that a right to terminate is irrelevant to that requirement of mutuality of obligation, as I'll show you...
I thought you said it was relevant, but it pointed in the...
Not to mutuality of obligation. Not what McMeechan is doing is where it is bringing it into account is not at the RMC Lim 1 stage, is there the irreducible minimum mutuality of obligation. It is at the third stage, and you can see that from 425E, where they are weighing all of the other conditions of the contract. What points in favour of what's consistent with a contract of service, what's consistent with a contract of employment, and they are saying at that third stage, so we've moved past mutuality of obligation, and it's at that third stage they're saying they're taking it into account at that stage, not in the context of mutuality of obligation, but as to another condition, and does it point one way or the other? Here they say actually it points in favour of employment.
Wait, sorry, when you say it points in favour?
Sorry, so it's the power of the contractor to bring any assignment to an end. That's it.
Where is that?
That's
not clear of the relevance of that in this case.
In which case, sorry?
Present case.
So the present case, so I say to the extent it's relevant, to the extent the right to terminate is relevant, it's not relevant at RMC Lim 1.
I follow.
It's If it comes in anywhere, it comes in at stage 3 when you are looking at all of the circumstances of the relationship, and in particular the other conditions. At that stage, and that's what the Court of Appeal were doing in McMeechan. Remember, actually in McMeechan, they're effectively acting as the first instance evaluator because this exercise hadn't been carried out below. And what the Court of Appeal are saying, and when they're looking at the factors that go to a contract of service, so of employment, one of the factors they put in that basket is the power of the contractor to bring any assignment to an end.
But I think the difficulty I'm having is the assignment here. What you're saying on the facts of our case is the assignment.
The individual match. The individual match engagement.
So you're addressing the power of the appellant to bring the refereeing of a particular match to an end.
Yes, because that's what the FTT rely on, and they rely on it in the circumstances of Lim 1, and you have my submission that that's irrelevant to Lim 1. But I go further and I say, even to the extent it is relevant at Lim 3, it actually goes the other way, and there is no recognition in the decision. They treat it as all going in the favour of, well, they don't actually do this at all because they don't carry out that balancing exercise. But even if one would say that that's what they did do, there is no recognition of the fact that the employer's right to terminate actually is a factor that points to a contract of employment.
But isn't the difference here that Mr. Peacock was pointing to was that here the individual contract, separate from the overarching contract, is actually a 6-day-long contract starting on the Monday when the referee offers to referee the match on the Saturday, and that's accepted. And that even within that, never mind the overarching season-long contract, there is still no obligation to provide the work. So I can see that you're right to say, if what you're looking at is actually given that the person is doing the work, then the question of whether there's an obligation to provide him with work isn't relevant, because that's the hypothesis on which you're examining the contract. But that's different here because there's a sort of 6-day contract, and even looking at that individual contract, there's no obligation on them to let him come and referee the match.
Right, and so the answer to that, my lady, is twofold. First, the relevant obligation on the part of the employer is simply to pay for work done. It's not an obligation to provide work, and that's Ready Mix Concrete, and I'll show you the other authorities that make good that point. The second answer to it is, even in the context of this, even in McMeechan, in the context of so the assignment is a 4-day assignment at Sutcliffe, at the catering company. So even if you were to apply that sort of analysis to it, starting at when they offer and accept, so they agree to work to do the 4-day assignment. If my learned friend is right, what you'd have to show is that the agency had an obligation to provide 4 days of work with Sutcliffe. But the effect of condition 10 is that at any point during those 4 days, the contractor, the agency, can say, I'm terminating the contract. So there is no obligation to provide. In that sense, if that's how you're... it seems to me that the point is the same. It's the same as our case.
In this case, suppose the FTT might have found, although they didn't, that until the match day, until the referee turned up for the match, there was actually no contract, but just a mutual statement of intent. In that case, it would still be the position that for the match period, once he was there and refereeing, he was performing under a contract in which he was entitled to be paid for what he did. In fact, they went further and they said that there was a contract from the beginning of the week. And at that point, there was, I think, although their reasoning's a bit inconsistent, an obligation to pay for work done. It's just an obligation that they had a right to cancel if they chose. But it's still a contractual obligation. And if it isn't cancelled, then it's entitled to be paid.
Yes, my lord. And that's the problem, my ladyship, with the question that you're posing, is that on that analysis, that would only work if the FTT found that there was no contract entered into on the Monday and that the contract only started on the Saturday. But how can you be in a weaker position if the contract is entered into on the Monday as opposed to the Saturday? And the error in my submission that the FTT fell into is that and where in my submission this confusion has arisen is because of the primary argument that was advanced before the FTT was that there was no contract at all. The secondary argument was if there was a contract, it was entered into when the referee arrived.
But they said there was not even a contract on the Saturday afternoon.
When the referee arrived on the Saturday.
They said then there was a contract.
That's the alternative argument.
Alternative, but the primary argument,
yeah,
never at any stage a contract.
that's the primary argument. I can take you when I come to it.
No, don't worry. I'm not surprised it's not run again now.
No, but with respect, my lord, in my submission it illuminates and informs the context of it. So that what they've done is they've drawn those arguments and they've imported them into the analysis here on mutuality of obligation. And because, as I say, the primary argument, no contract. Secondary argument, if a contract came into existence at all, it was only when the referee arrived. Why? Because they said he could back out, because of the circumstances in which they wouldn't attend. Our argument was, no, the individual contract comes into effect on the Monday when you, with the offer and acceptance. Also note, and this is referred to in our printed case, I'll give you the paragraph reference. On that Monday, once you've had the offer and acceptance, the appointments to all of the matches are published to all of the clubs, the media, competitions. So on the Monday afternoon at 4 o'clock, that list everybody knows who is refereeing on the Saturday. If it's a Tuesday game, it happens the previous. If it's a Wednesday game, rather, it happens the previous week Tuesday. So the clubs know long in advance who is refereeing that game. But my lords, can I just pause here? I'm conscious that I am going to go through these points when I come to the decision, and I'm sure it's my enthusiasm. But
well,
can I just?
You said the FTT's error was, and then you've described the context in which you say the error occurred. But in a nutshell, what do you say the error was?
Is that when they say at the end of paragraph 168 that there is no comparable obligation outside the actual performance of the contract.
No what obligation?
Sorry?
No what?
No obligation to
provide work.
No, not to provide work. For the referee to no contractual obligation to perform the work, and the engager to pay for work done. You'll see the quote. The quote is at the end of 168. Perhaps we should just go to it now. End of 168.
I thought it was 162. You might
162. I'm sorry, I'm getting ahead of myself on control. 162. 192 of the key documents bundle. It's internal page 40 of the decision. Do you see it says?
Well, yeah, I see that. But Prater, the teacher, didn't have a right just to withdraw, did they?
And can I show you when we get to Stevens?
I mean, did they?
Did the teacher have a right
to withdraw, having been assigned a pupil?
Well,
was she entitled just to say, "Oh, I've decided to"?
I think what I can say is that I don't think there is an express termination at will, which is why when we come on to look at the other authorities, Stevenson next, it's that, because of course it wasn't an issue in that case as to they weren't construing the effect of a right to terminate at will on mutuality of obligation, whereas that arises squarely in.
But I mean, Lord Justice Mummery says the teacher was under an obligation to teach the pupil.
Yes.
If one looks back at paragraph 159, the tribunal have already found that under the contract the referee would agree to officiate and PGMOL would agree to pay fees.
Exactly.
So there was an obligation to do work in return for fees.
Exactly, and so the obligation is there, and this is.
Sorry, I'm just because what I mean. The point they're making in 162 is that there's no comparable obligation to that imprater. That may be right.
It may be right, but it doesn't negate. It doesn't mean that there is insufficient mutuality of obligation for an employment contract, and that's the. And I'll come back to the point.
And that's because you say you have to look at, you have to take it as read when you're not dealing with the overarching contract. That work has been provided, and there is an obligation to pay for it.
So it is at the point at which you enter in the contract. The individual contractually undertakes to officiate the match on the Saturday. That's the contractual obligation. That's the contractual undertaking. And in return, the engager contractually undertakes to pay for the work, any work done. And that's the offer and acceptance you see the beginning of paragraph 159, because you have to read the end of paragraph 159 with the beginning where they find the contract, and they say, third line, under the contract, the referee would agree to officiate, whether as a referee or fourth official, and PGMOL would agree to pay fees and expenses at the specified rates. So that obligation, undertaking, arises on the Monday. And it is not negated or rendered insufficient by any right to terminate at will. And if I can then go on to the authorities that...
Can I just raise this with you, though? Would you not have to ask yourself, well, is that consistent, though, with this being a contract of employment? I mean, the employee has yet to do any work, because the time for doing the work is on Saturday. And if on Tuesday they have a change of mind, and they're entitled to withdraw, quite an odd contract of employment where no work has been done yet, and the employee can say before any work is done, I'm not going to do it. And he's fully entitled to do that.
Well, as I say...
Maybe you say that comes in at the 3.
There are 2 points there. The first point is it's not a lim 1, it's not a... That's why the Court of Appeal say when they say it's immaterial. It is immaterial to whether or not, to mutuality of obligation. Is there sufficient mutuality of obligation for this to be a contract of employment? To the extent it's relevant, it's the other side of the McMeechan engager's right to terminate. So they cancel themselves out. But in any event, that's the,
well, would you say,
that's the
would I say, I mean, it follows from your submission that having accepted the appointment on the Monday, and then on Wednesday deciding not to go ahead with it, you would say he was employed between Monday and Wednesday?
Yes.
Right.
But of course, in that situation, what's that going to go to? In the sense that he can't have a claim for wages. There's no tax issue or social security issue because there's no payment, no obligation to pay. And that's why it's relevant that, and as the cases say, it's relevant in this context that you are concerned with cases where work has actually been done, because that's where these issues arise practically. And but also, my Lord, can I take issue with this point when you say that the obligations only arise the work is only on the Saturday? Of course, as I'll come on to show you, there are other obligations. So once he takes the appointment on the Monday, he's under a contractual obligation not to do anything between the Monday and the Saturday that will compromise his impartiality or independence. And of course, that's one of the examples given of where where PGMOL do terminate the contract before the Saturday, is because the referee has tweeted. and that's a breach of the obligation which subsists during the individual contract not to do anything that impugns his impartiality. It's this point about there are relevant factors that occur before the arrival at the game. But, my lords, can I come back to this, please, after going through the authorities? Because I do say that I'll show you that Stevenson, Court of Appeal in Somerville is a very good example of where they expressly address this point about what it means by undertakes, and also Uber is also relevant. So,
You say that the ability of the employer to terminate is a stage 3 question, and it's on the balance of being a contract of service because of subordination.
I say to the extent it's relevant,
to the extent it's relevant. But in this case, of course, there was the countervailing entitlement of the referee.
And that's why I say they cancel each other out. So it becomes a neutral factor. But
that's a side that, and the referee's ability to cancel goes to their independence, their freedom to choose, and so on. And so one could imagine a contract which was one way only, one way or the other way, and that would be quite a strong pointer to it being a contract of service or not a contract.
And that was McMeechan, of course, because
So
in
you said
McMeechan,
neutral.
exactly. And also, I'll take you also when we come to Drake, I hope I have time, to Drake, where Drake raises the very serious public policy reasons why, which were alluded to by my Lord Legate, I don't know if it was by reference to Drake, yesterday, about how one has to be very careful about the weight or taking into account a right to terminate at will. But
We'd better let you develop your authorities.
thank you. Could I then please ask you to go to 472? Judge, can I, my lords, ladyship, can I just say this though, please? All of this though, the discussion that we've just had about whether it goes one way or the other, is all limb 3. It's not, doesn't go to sufficiency of mutuality of obligation. And so when the error of law of the FTT is to treat it as relevant to the limb 1, is there sufficient mutuality of obligation? So we don't get into, in this case, the questions that might have arisen had it been taken into account at the balancing stage. And I'll make that good when I come back to the decision, if I may.
But it would be relevant if one was considering whether the overarching contract was a contract of employment or not. Where the overarching contract falls down on the FTT's finding. I mean, generally, rather than in this particular case.
So if it would only be relevant in respect of an overarching contract if there was the necessary mutuality of obligation in the overarching contract. So there was the obligation to offer and accept work in the gaps. There was the limb 2 sufficient framework of control. Again, at third stage, it might come in at that point. But the one thing that what the FTT did not find is that there was a right to terminate the season retainer at will. One thing that gets lost in all of the analysis is that, of course, and I will get back to the authorities, of course, you've got a range of cases. And the typical Windle case is where you don't have an overarching contract. So there are no obligations of any kind, no contract in an overarching contract. That's one side of the spectrum. The next stage, though, which is where we are, is that you do have an overarching contract that does have obligations, just not the obligation to offer and accept work, but obligations relevant to the work in the gaps, and also has obligations that apply to the individual contract. And so it's very dangerous just to even say, well, even at that third stage, there's an absence of mutuality of obligation. Yes, but look at what else. That's tempered by and qualified by the fact of the other terms and so on. But again, that's not this case because that's not the analysis of the FTT. Can I then please go to Stevenson at page 472?
Can I, before doing so, just flag up one issue?
Of course.
When my Lord Hodge asked you what the error of law was, you took us to paragraph 162, which is at page 192 of the
Yes.
core bundle. But I was a little uncertain, and don't address it now, but I'd like to have the answer at some stage. It wasn't exactly the error of law found by the Court of Appeal at paragraph 122, page 113.
I'll come on to that. Can I, though, also, just on my feet, just answer, I don't say that's the only error of law. The other error of law is in respect of 159, where they say some, where they identify the some level of mutuality. That some are, as I'll show you, the fundamental mutuality of obligations that provide the sufficient mutuality of obligations necessary at stage 1. So it may be, if I was putting them in order, that would be the first.
So the sum level mutuality you say was sufficient mutuality.
Exactly. And this next case, as I'll say in my submission, makes that very clear. So then we go to 472 of the authorities bundle. This is Stevenson. It's an appeal against an ET finding that insufficient mutuality of obligation to establish a contract of employment with the end user of his services. Initially, the services were provided through an agency before becoming an employee of an end user. For unfair dismissal purposes, he needed to rely on the initial period of work through the agency to achieve the then 1-year qualifying service for unfair dismissal. So here, it was looking at, was there the necessary mutuality of obligation, not as between the individual and the agency, but the individual and the end user. Then can I ask you to have a look at 474, please? Yes, 474. You'll see that at paragraph 6 to 9, they set out the key written terms in the agency end user and the agency individual contracts. You'll see that paragraph 6 is the agency end user contract, and at 7 to 9 is the agency individual contract. You'll see at paragraph 8 is the no obligation to accept any assignment. And then do you see over the page at 475, there is the bilateral right to terminate. And again, you'll see that so both the employer and the employment business have the right to terminate at any time. Then do you see at paragraphs 10 to 11, 10 to 17 are very important passages, and these are the passages that are endorsed by Mr. Elias when he's in the Court of Appeal in Quashi, where he quotes these paragraphs. He quotes 11 to 14. He qualifies the last sentence of paragraph 14, which isn't the relevant one for our purposes. So you see in paragraph 10, he cites Lord Justice Longmore, in Montgomery, whatever other developments this branch of the law may have seen over the years, mutuality of obligation and the requirement of control on the part of the potential employer are the irreducible minimum for the existence of a contract of employment. So critically there, that's where you get to sufficiency. And it's referred to as sufficiency in Montgomery. Mr. Justice Buckley says you've got to find sufficient mutuality of obligation and sufficient control before you move on to stage 3.
I don't understand that in relation to mutuality of obligation. No. So either you've got mutual obligations or you haven't.
Yeah. Well,
there isn't some sort of matter of degree in it. So kind of half an obligation. So
in my submission, what I think Mr. Justice Buckley must be referring to there is, of course, and you'll come on to see that they talk about mutuality being used in 2 senses. The first sentence being, is there a contract at all?
But then if there is, then the second part is it one of to do work yourself in return for pay?
Yeah. And I think
either it is or it isn't.
And I think that may be where the confusion arises. But but in terms of the FTT's use of sufficient, in my submission they can be forgiven for it because it derives from those authorities that describe it as sufficient.
Right.
But you'll see that that's not the language that Ms Justice Elias uses.
So it's not, you say it's not a kind of qualitative test, it's a quantitative test.
I hesitate to say quantitative. It is. There are elements that you have to meet. So, as my Lord Legate has just described, there has to be a contract. It has to involve an obligation on the part of the employer to pay for work done, and it has to involve an obligation on the part of the employee to do the work personally.
Yes. So you say that mutuality of obligation has developed arms and legs as a concept, but if you go back to RMC stage 1, that's all that's required.
Exactly, and you'll see that the word that Ms Justice Elias uses in these passages that I take you to is not sufficient. He describes that what I've just described as being the fundamental mutual obligations, which would be consistent with what my Lord Legate has just put to me.
But that doesn't say anything about whether it's a contract. Well, I suppose the element that it has to be provided personally is part and parcel of whether it's employment or services.
Yes, and also the obligation on the part of the engager, the employer, to pay the wage. So Kwashi being the example, there was a contract between the club and the individual, the dancer, but there was no obligation on the part of the club.
Yes, but the payment of money for the work done doesn't help you distinguish, where there is payment of money, doesn't help you distinguish between employment and services.
I would accept that. But the personal service does. And that's why there is a whole raft of authorities on the personal service element of the mutuality of obligation requirement.
And that may be why in section 230 of the ERA that we were shown yesterday, and also section 296, that is then pulled out as being the obligation that turns something which isn't a contract of employment into a relevant contract for those particular employment rights.
But with respect, the obligation of for a worker, the statutory definition of a worker also involves an obligation to perform the work personally.
Yes.
And that's why Pimlico Plumbers, in the Court of Appeal, when the Master of the Rolls, Sir Terence Etherton, addresses the characteristics of a substitution clause, when a substitution clause will or will not negate the necessary mutuality of obligation requirement for personal service, he refers to the employment cases. So there is no difference, and I'll show you the other authorities. Lord Justice Underhill addresses this in Windham. The mutuality of obligation applies in the same way to worker status. But can I do that when I come on to those authorities, please? Can I though just stick with Ms Justice Elias in Stevenson? The significance of mutuality is that it determines whether there is a contract in existence at all. The significance of control is that it determines whether, if there is a contract in place, it can properly be classified as a contract of service rather than some other kind of contract. Now, there are two issues with those first two sentences that I'll come on to show you. 12, the issue of whether there is a contract at all arises most frequently in situations where a person works for an employer, but only on a casual basis from time to time. It is often necessary then to show that the contract continues to exist in the gaps between the periods of employment. Cases frequently have had to decide whether there is an overarching contract or what is sometimes called an umbrella contract, which remains in existence even when the individual concerned is not working. It is in that context, in particular, that courts have emphasised the need to demonstrate some mutuality of obligation between the parties. I pause there and put in parenthesis all of the cases relied upon by my learned friend. As I've indicated, all that is being done is to say that there must be something from which a contract can be inferred. Without some mutuality amounting to what is sometimes called the irreducible minimum of obligation, no contract exists. That's a relevant point because it's...
I'm not sure whether he's really fully grappled with it there, because it's not just whether there's a contract when it's a question of whether there's a contract that covers the gaps, but it's also a question of whether it's a contract to do work for pay, and there you do look at whether there's some obligation. on the employer to provide work.
And in my submission, I think the issue there is it's compressed reasoning. I think you have to read that into that because you know that the cases he's referring to are Carmichael, Nethermere, etc. And you'll see that what he describes in Quashie is that what he was trying to do here was draw the strands together from the cases. But the next point, though, paragraph 13, the question of mutuality of obligation, however, poses no difficulties during the period when the individual is actually working. For the period of such employment, a contract must, in our view, clearly exist. For the duration, the individual clearly undertakes to work and the employer in turn undertakes to pay for the work done. Can I just pause there? It's clear there that he's referring there to the second element of mutuality of obligation, or really the second and third elements if you ignore substitution. The obligation on the employer to pay for work done and the obligation on the employee undertakes to do the work. So that's why it's clear he's not just talking about the existence of a contract. Then importantly this, in the context of a case that involved a right to terminate at will on both sides, this is so even if the contract is terminable on either side at will. Unless and until the power to terminate is exercised, these mutual obligations to work on the one hand and to be paid on the other will continue to exist and will provide the fundamental mutual obligations. And Lord Stephen asked me about the error of law. That's where I say that in that paragraph at the end of 159, the error of law is treating them as some as opposed to the fundamental mutual obligations required under RMC Lim 1. And they are, and that goes to my Lord Hodges' point about the contract taking place on the Monday when the offer and acceptance is made. From that Monday, what is the content of that contract? What is the contractual obligation undertaken? It is the obligation to officiate on the Saturday. And that will subsist unless and until the contract is terminated.
And you say the possibility that it might be terminated doesn't make it flimsy in some way.
No, but with respect at Lim 1, it's not a question of is it flimsy. It's a question of, for mutuality Lim 1, has the individual contractually, has he undertaken to perform the work personally? Answer yes, irrespective of a right to terminate. The right to terminate does not in any way remove or denude that obligation from being the fundamental obligation on the part of the employee required by RMC Lim 1. My Lords, then 14, the issue whether the employed person is required to accept work if offered or whether the employer is obliged to offer work as available is irrelevant to the question whether a contract exists at all during the period when the work is actually being performed. And just can I make good one further point just before I go? That last paragraph also, though, goes to paragraph 13, addresses directly paragraph 162 and the points that my Lords were putting to me about paragraph 162. Because there, Mr. Justice Stevenson is expressly addressing the impact of a right to terminate at will on the necessary mutuality of obligation. What he's identifying is that the existence of the right to terminate at will does not mean that the obligation to undertake work personally doesn't arise in the first place. Paragraph 14, the issue whether the employed person is required to accept work if offered or whether the employer is obliged to offer work as available is irrelevant to the question whether a contract exists at all during the period when the work is actually being performed. The only question then is whether there is sufficient control to give rise to a conclusion that the contractual relationship which does exist is one of a contract of service or not. And of course, that's the sentence that he qualifies in Quashie where he says, actually, that's a bit simplistic. You've obviously also got stage limb 3. But it is relevant, my lords and my ladyship, that in contrast to his position yesterday, a fundamental plank of P. Jamal's case to date, and indeed I think it's in their printed case, is that in Quashi, Lord Justice Elias was seeking to qualify not just the last sentence of paragraph 14, but all of what he'd said. And yesterday, I think for the first time I heard my learned friend say, accept, that actually, I think Lord Hodge put to him, that that only refers to the last sentence of paragraph 14. And he accepted that the qualification in Quashi didn't go as far as he needs it to. That's because he is endorsing in the Court of Appeal in Quash, quotes endorsing paragraph 13, which is a complete answer to this appeal. Can I then just go on to 15 and 16, please? We note that in Montgomery and Johnson Underwood Limited, Mr. Justice Buckley in an obiter statement said, "For my part, I would accept that an offer of work by an agency, even at another's workplace, accepted by the individual for remuneration to be paid by the agency could satisfy the requirement of mutual obligation. I put it no higher because it would be necessary to look at the circumstances carefully and realistically. It may, for example, be more difficult to find that necessary mutuality in a very short assignment as opposed to one which has or had become more permanent." And what Mr. Justice Elias says is, with due respect to those observations, it seems to us that, in fact, however short the assignment, there will be the necessary mutuality of obligation so as to establish the existence of a contract with someone when work is accepted and the obligation to pay arises. And you see, it's when work is accepted. Can I then ask you, please, to go to, again, I'll try and take this quickly. Can I then ask you to go to 17 to 19 as the ET's reasoning? And you'll see at 17 to 19, what the ET relied on was that because the claimant had a right to walk off and terminate the job at any time, the ET had found that that precluded the requisite mutuality of obligation. That's effectively the approach taken by the FTT in our case. Can I ask you to then look at 27 to 30? You'll see that at 27, McMeechan, you'll see 27, I think, records submission relying on McMeechan. Then this paragraph 28, they cite the passage from Lord Justice Waite and McMeechan that I've taken you to. The better view is if, is not whether the casual worker is obliged to turn up if he turns up. And then 29, Mr. Mansfield for the respondent, so it's Gavin Mansfield for the respondent company, submits that the decision of the tribunal on this point was correct. So that's his primary argument, was that the tribunal had not erred in law and that it was entitled to conclude in circumstances that the fact that the applicant could walk off the job at any time demonstrated a lack of mutuality of obligation. For reasons which we have already given, we reject that analysis. The tribunal concluded that there was no mutuality of obligation because the applicant could at any time walk off the job. However, there is no reason why there cannot be the mutuality of obligation for the duration of the working relationship merely because in the future there may be no obligation to accept further work or because of a right to terminate the contract at will. So, my lords, that's paragraph 30. And so, in my submission, all of this goes to the point that the FTT's analysis was wrong in law, and the EAT there is entirely consistent with McMeechan, and also I won't take you to it, but with what Recorder Underhill said in Byrne Brothers at paragraph 26, which is referred to by the Court of Appeal in paragraph 68 of its decision, because you'll recall that in paragraph 68 of the Court of Appeal's decision, they talk about the authorities which show that a right to terminate at will does not negate.
Which paragraph in Byrne Brothers?
It's paragraph 26. And you'll see that the Court of Appeal refer to us relying on a number of authorities. It wasn't the only one.
Byrne Brothers, yes.
And Stevenson as well.
Stevenson and Byrne Brothers. At
But they
paragraph
refer to other. They say that we relied on on a number of authorities. One of the. I'm not going to take you to Byrne Brothers, but one of those other authorities was Drake, which is in your bundle, please. And Drake is at 610. So Drake is so it starts at 607. So EAT, another judgment of an experienced employment appeal judge, His Honour Judge Richardson. You'll see when we come on to control that I'll be taking you to a judgment of his on control at Troutbeck, which has been cited on a number of occasions. But here, Drake and Ipsos Mori, he is dealing there with market researchers, a bit like as in market investigation, that Mr. Justice Cook was dealing with. But here, dealing with Ipsos Mori, maybe focus groups, but anyway, Drake and Ipsos Mori, but here, unlike Stevenson, a direct contract case, so not a tripartite case. Drake and Ipsos Mori. Can I just take you to the paragraph 3? Well, paragraph 2, you'll see it says C worked on an assignment by assignment basis as a market research interviewer. Paragraph 3 says that the ET held that the claimant was not an employee because there was no mutuality either from one assignment to another or during the course of any individual assignment. So not just in the gaps, but during the course of any individual assignment. You'll see at paragraph 8, there's a reference to the Respondent's Interviewer Handbook, which provided that while there was no obligation on R to offer work to the Respondent to offer any work to anyone interviewed, and no interviewer was obliged to accept any work that was offered, once a job had been accepted, it is considered as a verbal contract that you will complete the job within the deadline and according to the survey specification. That's important, as we'll come on to see. Then can I ask you to go to paragraph 18? You'll see that the ET found as a fact that not only was there no obligation on the Respondent to provide further work to the claimant upon completion...
Sorry, where are you reading?
Sorry, Jerry. 8.6, please.
8.6, thank you.
So it's paragraph 18, but 8.6, so...
Yep.
Page 609.
Page 609, apologies. Right-hand column. It's the IRLRs, so different format. So... ET found as a fact not only that was there no obligation on R to provide work to the claimant upon completion of a particular assignment, but that it was open to the Respondent at any time to remove an assignment that had been allocated and for an interviewer to return an assignment that had been allocated. It found that there was no contractual obligation on either side for the agreed assignment to be completed by the person to whom it was originally allocated. And then do you see at paragraph 32?
Paragraph 32.
Please, yes. Page 611. Applying the reasoning in Stevenson to the case in hand, I have no doubt that there was a contract in place and the requisite mutuality when the claimant was actually undertaking an assignment for the Respondent. The fact that the assignment could be brought to an end does not mean that there was no contract in existence when the assignment was continuing. Plainly, there was a contract while the assignment was continuing. There was an agreement to undertake work in return for payment. So that's the identifying the fundamental obligations. When the Respondent in its handbook described the acceptance of an assignment as a contract, it was correct. So that's important. And that's, of course, the equivalent finding in ours is the fact that there was a contract on the Monday. Then this. The fact that either side might terminate the contract at will does not mean that there was no contract. If therefore the employment judge was using the concept of mutuality in this primary sense, he was, to my mind, certainly wrong. I will consider his reasoning later in the judgment. And then, do you see 33? He says, there is, however, a secondary sense. So the first sense of mutuality of obligation is the point one, is there a contract at all? He then says, there is, however, a secondary sense in which the concept of mutuality is sometimes used. In this secondary sense, it is not relevant to the question whether there was a contract at all, but to the question whether the contract was a contract of employment. After a review of the authorities, it was described by Miss Justice Langstaff in Cotswolds in paragraph 40 as a requirement of mutuality specific to contracts of employment. And in paragraph 48, he said, it cannot simply be control that determines whether a contract is a contract of employment or not. The contract must necessarily relate to mutual obligations to work and to pay for or provide it to what is known in labour economics as the wage-work bargain. And of course we know that in Cotswolds they were there dealing with an overarching contract. And then, can I then ask you that in paragraph 34, and as I say, the reason why there's a bit of confusion about Stevenson is because in Stevenson, as I showed you, Miss Justice Lyons talked about it as being the relevance is there a contract at all. But as I showed you in paragraph 13, he also found the relevant wage-work bargain there, the obligation to work and the obligation to pay for work done. And that's that secondary sense. Paragraph 34, in this secondary sense, the concept of mutuality is with reference to the nature of the contract, particularly, it seems to me, with reference to the first test in the ready-mix concrete case. The emphasis is not really on mutuality as such, but on the nature of the bargain between the parties. Speaking for myself, I would prefer to use the concept of mutuality only in relation to the question whether a contract existed between the parties, but it is inescapable that the concept of mutuality sometimes creeps into the question whether the contract is a contract of employment. And that's, is there the work-wage bargain? He then says this, though. It is difficult to see why the fact that a contract is terminable at will should be determinative of the question whether the contract is a contract of employment. Agreements to do work personally in exchange for remuneration are of many kinds. Casual agreements may be less common now than they once were. Now, of course, just pausing there, this predates, you can tell the date, 2012, this predates the gig economy and the flurry of cases that we've seen since. Casual agreements may be less common now than they once were, but I do not think there is any doubt that casual labour, which may quite often be terminable at will, can be, and historically often has been, provided pursuant to a contract of employment. It would, moreover, be remarkable if a contract which otherwise satisfies the test for a contract of employment could be taken out of that classification merely by providing that it is terminable at will. And so...
so he's referring to a policy point, really.
Yes, my lords, my lady. And of course, that policy point is, in my submission, significant in our case, because even when you're looking at the third stage, in my submission, that's a powerful reason to treat with care, even at the third stage, the right to terminate at will. But at the first stage, if, as the tribunal do here, they say that the right to terminate at will means there's insufficient mutuality of obligation, well, that is treating it as determinative. Which is a further reason why it cannot be right that it is a relevant consideration to take into account at the first limb stage. Because, as I say, that first limb stage is a knockout stage. It's why on this appeal, I have to win on both mutuality limb 1 and control limb 2.
Right, so it's a knockout stage at this point. So you don't then go forward to the third stage, but if there is found to be mutuality of obligation, you go forward to the third stage, but you may at that stage say it's not a contract of employment.
That is the focus of the third stage, is to, as a balancing exercise, looking at all of the terms of the contract and the surrounding circumstances. And so, because at that third stage you can look at all of the terms and the circumstances, I'm not going to submit that you can't at the third stage take it into account. It's not part of the factual matrix. But what I would say, based on the policy point made by His Honour Judge Richardson, is that at that third stage one has to be very careful on public policy grounds about how one addresses termination at will. Can I put it that way? Even
But is there any policy point arising in the application of the test in this context, in the tax context, rather than the employment rights?
Right. So yes, but can I answer that in 2 stages? One, it's common ground in this appeal. My learned friend opened it's in the statements of case, printed case, but it's also he opened the appeal to you expressly on the basis.
Yes, it's a common law test. Yes.
It's the common law test, but also it applies in the same way to both contracts of, so both in the tax case and the ET and the employment context, and therefore it is the same. But also, and I agree with that, but there is a second point. One has to remember that, yes, one always focuses on the tax aspect here. And I say there would be tax reasons as to why, from a policy, if you're interpreting a tax statute, why you have to interpret it purposively. But even here, but we have to remember that we're also dealing with national insurance contributions. It goes to your social security rights, your right to statutory sick pay. But can I, so that's paragraph...
So in a case like the present one, if the referees are in employment, then on the Saturdays, national insurance contributions will be payable both by the employer and by the employee, yes, in addition to the national insurance contributions made by their employer from Monday, yes, to Friday.
Because and the appeals that are before your lordships, the underlying substantive appeals, are against both Reg 80 tax determinations and Section 8 social security decisions, as is often the case.
Is the liability to pay national insurance contributions only on the appellants in this case, or also on the individual? It's
the class. So it would also be on the individuals, but it's the class, is a different class of contributions, depending on whether you're self-employed or employed.
No, forgive me, I'm assuming they're employed. Assuming that they're employed.
Whether they're employed or self-employed, there'll be an obligation to pay national insurance contributions.
Yes, they'll pay class 1 if they're employed, class 4 if they're self-employed.
Exactly.
Have they been assessed to that, or whatever the procedure is?
Yeah, have the individuals.
Yes.
So the way it works is, of course, is that the obligation is the PAYE obligation on the employer to deduct, or to deduct it, and that's why
to deduct the national insurance contributions as well as income tax.
And so that's why you've got the Section 8 decision against the employer.
But when you assess the employer for PAYE, presumably you have to give them credit for any tax that the referees have in fact paid on those earnings, on the assumption that they're independent.
So that's how it all. Yes, the answer is yes. And it's why in these the answer is yes. But of course, what there is no credit for is the employer contributions, because none have been paid.
For national insurance, yes.
I'm sorry to pursue this, but so far as the employee contributions is concerned, who is liable in this case to pay them?
So, well, it's a two-stage part, because of course you've got the underlying liability, but you've got the mechanics for collection, which is the PAYE.
Yes.
And so the way that the contributions are collected. So it's the distinction, Lord Dunedin, between, as my lordship knows, the different stages. But it is so whilst the liability to pay is on the individual,
yes,
the collection mechanism is under the PAYE regulations is on the employer to deduct. That's why in your payslip.
Yeah. No,
right, but insofar as the referees have been paying tax, I mean, the tax rates are the same, aren't they?
But you then get into issues about deductions and so on and so forth. And of course, and that also, though, goes to, I'm very conscious of time, but it goes to why I said about the social security point, but I also said there's a tax point, policy point, which is, of course, Parliament has. There are different tax regimes for the employed and self-employed, and Parliament has, and there are important differences between the two, and Parliament has Parliament's purpose is, or intention is, that people who are engaged under a contract of service are taxed on a particular basis. And so, therefore, with respect to all of the policy reasons that my Lord Legate applied, obviously it's a different context, different, not in employment protection, but there are still purposive reasons.
But you're not suggesting, I mean, you're just saying it's a common law definition. You're not saying it should, that we should interpret it according to whether it's a tax statute or employment protection. I mean, this is a tax context.
Yes.
And you're not saying there's anything in the tax context which means that any sort of special or different meaning should be given
with respect,
than a common law.
I say this, that the answer in both is the same. It's common ground here at the bar that the answer, whether it's an ET or an FTT, is applying the common law test. The answer, whether you're an employee or a self-employed, should be the same. Point number one. Point number two, in Uber, Lord Legate talked about purpose of construction, and of course he relied on a tax case.
But Uber wasn't about the common law, was it?
Well, no. But this is important, though, my Lord, for two reasons. One, the definition was section 230. 230A so the first part of the definition of a worker is a contract of service. And if you recall, in AutoCleanse, both parts of the statutory definition were in issue. They found that the valeters were Lim A workers, i.e. they were engaged under a contract of service, the common law definition, and they were also, in any event, held, even if they were wrong on that, they were Lim B workers. So you had the same contract. So, and the section 230A, I think it's section 2303A, uses, as does section 4 of the of ITPA, defines employee by reference to, including, a contract of service. And you come back to the point, my lords, and I've given you the policy, and as I say, they're both. Arrowtown is a tax case about interpreting statutes purposively. And so it also applies equally in the tax context. I've given you the social security, the social security equivalent policy reason. But I fear that's a point of general principle, but not an unimportant one, but not directly relevant to the disposal of this appeal.
No, but in developing the common law, the court can take account of public policy, but unless we are interpreting a statute, which we're not in this case, the court would not wish to develop the common law in a way that was contrary to statutory provision. But there's no suggestion here that we're in that territory at all.
No. Yes, but also bear in mind, I would ask the court to bear in mind that even in an employment context, it's not just worker definition that gives rise to statutory employment rights, it's employment, contract of service. And that employment is defined, again, same as Section 4, by reference to a contract of service, the common law concept. So it's not so simple as to say statutory or common law. In circumstances where, as I sort of come back to the common ground, as between the parties, is that it's common ground, and it must be right, that either an FTT or an ET must be applying the same test and should reach the same answer. It would be intolerable if you had different answers depending on whether you were arguing employment status in the tax or the in the FTT or the employment.
It might or might not, but that's not what's facing us now.
No. Can I? Sorry, I've just. Okay. Sorry. So that was
Drake.
That was Drake. So I've taken you to 35. 36. There's the reliance on Meechan. And can I just make this point that you'll see that the reference to paragraph 8 of the judgment and paragraph 42. Those are references to the IRLR report, and that is 554A of the ICR report, which you have. and paragraph 42 is 565E. So paragraph 8 is the reference to condition 10, and paragraph 42 is the reference to the balancing exercise and it pointing the other way.
So we haven't got the paragraph numbers in the other report?
No.
No, okay. So,
Would you like me to repeat, though, the
would you mind?
the page
I'd be
numbers?
very grateful,
So
yes.
Paragraph 8 of the IRLR report is at page 554A of the ICR report. 554A.
Oh, yes. Thank you.
Apologies. And paragraph 42 of the IRLR report is at page 565E of the ICR report.
Thank you very much.
Sorry, and Mr. Pennell has been very efficient. Can I just give you the bundle references? Because I've just given you the case report references. So in respect of paragraph 8, the bundle reference is page 414. And in respect of paragraph 42, the bundle reference is page 425. And you see paragraph 38. It is true that Elias J's own preferred use of the concept of mutuality related to the question whether there was a contract at all, but the Appeal Tribunal's rejection of the Tribunal's conclusion that there was no mutuality such as to found a contract of employment carries with it the conclusion that a right to terminate the contract work is not inconsistent with the existence of a contract of employment, and the citation of Meechan is apposite in this context. Then at 39, he addresses an EAT decision in which the tribunal had treated a right of termination at will as negating mutuality, but notes at paragraph 40 that Meechan wasn't cited in Little, and if Little were treated as authority for the proposition that a right to terminate the contract work at will is inconsistent with a contract of employment, it would be contrary to the result and reasoning of Meechan and to the express view of the Appeal Tribunal in Stevenson. Moreover, for the reasons I have given, I do not think the proposition would be correct, and that's obviously the paragraph 35 reasons that he's given. Can I then just very briefly take you to the case of Woods, Somerset Woods? The reason for doing so is that in their printed case, but also I think yesterday in Millennium Friends submissions, and he'd certainly below, and the upper tribunal accepted this submission, it was suggested that Mr. Justice Langstaff in Cotswolds, and Williams in Cotswolds, took, in Millennium Friends' words, a very different view of the mutuality of obligation requirement from that of Mr. Justice Elias in Stevenson. So that's the submission. Can I take you to the case of Woods, please, which is referred to in our printed case? Can I ask you to go to page 632, thank you. I need not go through the do you see paragraph 8, please? I'm just taking you to the points of principle rather than the facts, but it is an individual contract case. So do you see in paragraph 7, talks about casual work and qualifying periods. Paragraph 8, so it's saying in the first type of case is the overarching contract. Second is in 8. The second is that they are employed under a succession of individual contracts, each of short, and it may be very short duration, but in respect of which, when they work, it is plain that they are providing their work personally for pay, thereby demonstrating a mutuality obligation between themselves and the employer at the time. So you've got Mr. Justice Langstaff also recognising that employments can be very short in duration. And you've got the point that whatever you decide in this case applies in both the tax and employment context. And you've got there Mr. Justice Langstaff recognising, as Mr. Justice Elias, and also recognised that in the employment field you can have contracts of employment of very short duration. They're not uncommon. Then he says at paragraph 9, so he talks about third line down. Here again, there is a need to make careful distinction between the cases which may be relevant. Many authorities are decided in the context of a choice presented by the parties as to whether the person providing work is self-employed or an employee. The distinction there between a contract for services or a contract of service is the critical one. It is this on which the court's decision focuses. Some may be concerned with whether the agreement is one of employment at all, as where the contract is one of licensing an individual to do work on the premises. And he identifies the golf caddy case as one of that, but also Stringfellows. Other authorities are concerned with the nature of the arrangement between the parties under which from time to time a person may be called upon to provide work. This, as I've pointed out, may be either an individual contract or a succession of individual contracts. Then at paragraph 15, please. So there was a question as to whether or not there was a statutory reason why they couldn't be employees. That's passed on. He says, here the judgment is to an extent deficient. It did not consider separately the case in respect of an overarching or umbrella contract and distinguish from them from those in respect of continuity of employment. So again, identifying the error in applying the principles in an overarching case to an individual contract case. Then he says this: such a distinction is clearly made by, for instance, Mr. Justice Elias in Stevenson and Delphi Diesel systems. He thought that without some mutuality amounting to what was sometimes called an irreducible minimum obligation, no contract existed when he considered an overarching contract. But at paragraph 13, he observed, and then do you see this? He quotes paragraph 13 of Stevenson. That's the one that I rely on, and the one that my learned friends suggest Mr. Justice Langstaff in Cotswolds in some way disagreed. But you'll see that he says at paragraph 17, that view, so the view expressed by Mr. Justice Elias in paragraph 13, was endorsed by the Appeal Tribunal in Cotswolds Development and Construction and Williams. So that's his own case. And it was noted in Prater that a succession of individual contracts for work, within each of which there was mutuality of obligation relating to the work provided and performed under the contract, could be contracts of service, despite the fact, etc. So that's at 17 rather. And then can I just finally take you to 37, please? It's page 635. So addressing the individual contract case, he says, 3 lines down, about 5 words in, I am and would have been prepared to hold that it would be painfully obvious that any person providing services for money as a registrar would, during the time they actually provided those services, be providing them personally under a contract with the council in the expectation of reward. There would, to that extent, limited extent, mutuality of obligation. In this, I see entirely eye to eye with that which Mr. Justice Elias expressed in Stevenson. So just pausing there, he's quoted paragraph 13 of Stevenson. He said in terms that he endorsed it in Williams, and if there was any doubt, in paragraph 37, he says he sees entirely eye to eye with Mr. Justice Elias. So contrary to the submission made by my learned friends, there is no relevant distinction between the analysis in Cotswolds and Stevenson. On the contrary, Mr. Justice Langstaff, another president of the Employment Appeal Tribunal, experienced employment lawyer, agreed entirely with paragraph 13, which we rely on. I then want to just briefly go to 2 worker cases because I say they are recent and they are relevant because they apply the employment cases on mutuality of obligation. But can I just, again, just addressing the point made by my learned friends that, well, you can really disregard these worker cases because the statutory test for worker is different. Can I show you what Lord Justice Underhill said about that in Windle? So Windle is relevant, it's 570, please. 638, please.
Which page number?
638.
638.
You'll recall these are the court interpreters.
638.
The relevant paragraphs, so I'll take it quickly. Can I just take you to 23 and 24, please? 648. Thank you. So you'll see at 21, the single question on this appeal is whether the EAT was right to find that the ET had misdirected itself by treating the absence of an umbrella contract as a relevant factor in the assessment of the claimant's employment status. This is not a worker status case, but it is a discrimination employment status case. And so, as you know, for discrimination purposes, we have the extended definition of an employee, which the courts have held is the same as worker status. And so what the submission was is, well, the employment authorities on mutuality of obligation are irrelevant to the worker status. 23, I do not accept that submission. I accept, of course, that the ultimate question must be the nature of the relationship during the period that the work is being done. But it does not follow that the absence of mutuality of obligation outside that period may not influence or shed light on the character of the relationship within it. It seems to me a matter of common sense and common experience that the fact that a person supplying services is only doing so on an assignment by assignment basis may tend to indicate a degree of independence or a lack of subordination in the relationship while at work, which is incompatible with employee status even in the extended sense. Of course, it will not always do so, nor did the ET so suggest. Its relevance will depend on the particular facts of the case, but to exclude consideration of it in limine runs counter to the repeated message of the authorities that it is necessary to consider all the circumstances. Then this, importantly, that would be my view even without any reference to Quashi. And we know Quashi is an employment status case. But I do not, in fact, think that what Elias J. said in the passage which I've italicised can properly be disregarded on the basis that the issue in that case was whether the claimant was employed under a contract of service. So that's what my learned friends are asking you to do in respect of the worker status cases that we rely on, Uber, Somerville, etc. Is say, well, you can disregard it because the question there is worker status, not contract of service. And the reason why that's wrong, the underlying point is the same. The factors relevant in assessing whether a claimant is employed under a contract of service are not essentially different from those relevant in assessing whether he or she is an employee in the extended sense, though, if I may borrow the language of my own judgment in Byrne Brothers, in considering the latter question, the boundary is pushed further in the putative employee's favour, or to put it another way, the assessment is lower. So pass mark, apologies, is lower. And so there you have, in my submission, a sound basis in the authorities as to why the submission that you should not take into account the worker cases on mutuality of obligation when considering mutuality of obligation.
Well, if somebody is employed under a contract of employment, then they are going to also be a worker, but it doesn't necessarily work the other way around.
No, but when you're considering, sorry, but this is talking about the Lim B definition of worker. So it's saying, so you've got the Lim A and Lim B, and as I understand Lord Justice Underhill, what he's saying is when considering the Lim B worker status, or as in this case, the extended definition of employment, it's relevant to look at the cases on mutuality of obligation in the employment context. Why? Because the tests are essentially the same, it's just the pass mark is lower. And as I'll go on to show you, in Uber and in Somerville, that's elaborated on. If I could then move on to those cases. But can I just, before I do that, just take you to one paragraph in Pimlico Plumbers, please, which is a, sorry. Can I then ask you then to go to, sorry, page 713. So this is Lord Justice Underhill revisits paragraph 23 of Windle. and he qualifies it. Do you see it, paragraph 145? So this is not the point about the relevance of employment status cases, it's the relevance of the absence of legal obligations outside the individual engagements. 145, he says, second, although the argument before the tribunal and before us was couched in terms of whether Mr. Smith was subject to a legal obligation to work or be available for a minimum number of hours, it should not be assumed that if there had been no such obligation, the evidence about what hours he worked in practice would have been irrelevant. It is necessary to distinguish two separate circumstances in which the issue of whether a putative employee or worker is engaged, so he's applying there both employee or worker, is engaged on a casual basis might arise. The first is where the substantive claim directly depends on their enjoying either employee or worker status in respect of their periods of work, e.g. because the claim concerns their pay or some discriminatory treatment in the workplace. I would add in parenthesis, or a tax and NIC case that is looking at the individual engagement. He says this, in such a case, the question whether the engagement is casual is indeed relevant, but only on the basis that it may shed light on the nature of the relationship while the work in question is being done. He cites Quashie and the paragraphs in Windle that I just took you to, but he qualifies it. But it is not only legal obligations that may shed light of that kind. If the position were that in practice the putative employee or worker was regularly offered and regularly accepted work from the same employer so that he or she worked pretty well continuously, that might weigh in favour of a conclusion that while working he or she had at least worker status, even if the contract clearly and genuinely provided that there was no legal obligation either way in between the periods of work. And in my submission, that's important, as I say, not for our case, but just when we see the passage in Windle often quoted, what's not often quoted is that important qualification in 145, which is entirely consistent with the judgment in Atoll House, that you don't just look at the terms at the third stage, you don't just look at the terms, you look at all the circumstances.
Well, you look at the, I think Athol House says you look at the circumstances which were available to the parties yes. when they entered into their contract. This, so this is going to a different point.
But with respect, in our case, it was known at the time the referees entered into the contract how many matches, at the beginning of the season, they know, both parties know how many matches there are, they know how many referees there are, and so they know that there will be the regular offer and acceptance of work. But, as I say, doesn't go to this case, the disposal of this appeal, but I'm just concerned in terms of the general principle, just to point that out. Can I then go to Uber, having said that I would? It's 781, please. Do you see it, paragraph 90? J, 781J, not suggested on their behalf that they perform their services under what is sometimes called an umbrella or overarching contract. So Uber's not an overarching contract case. Then this, Lord Leggett says at 91, and of course 91's an interesting paragraph in the sense that although my learned friends say that you should not take into account in an employment status case the worker status case, they themselves rely on paragraph 91 of Uber. But what I rely on is for 91, the beginning part. Equally, it is well established and not disputed by Uber that the fact that an individual is entirely free to work or not and owes no contractual obligation to the person from whom the work is performed when not working does not preclude a finding that the individual is a worker or indeed an employee at the time when he or she is working. And you see that Lord Leggett relies on the employment status cases, in particular McMeechan and Prater. And he quotes Miss Justice Elias in James and Redcats. It then quotes Windle, which would go to the third stage, which, as I said, has to be read in my submission with Pimlico Plumbers. Then, though, can I take you to the application of paragraph 91 to the facts of Uber, which you see at paragraphs 123 to 124.
I mean, just just on 91, what Lord Legate is saying, just to be clear about this, it doesn't preclude a finding. I mean, I don't think that's really in issue, is it, or is it? You say it is in issue. You say the appellants say...
Sorry, can I just see, where is it the preclude?
Well, in 91, yes. What you just read to
Yep.
us, it's well established, not disputed by Uber, the fact that an individual is entirely free to work or not, etc., does not preclude a finding that the individual is a worker or indeed an employee at the time when he is or she is working.
So that part of it doesn't. That part of it.
It's not in dispute.
It's not in dispute in this case, no.
No.
But you see that the reason it's not in dispute is because of when you look at mutuality of obligation, the requirement. But can I ask you to look at 123 to 124, 790, please. And the context is, you'll see the context starts at 121. The secondary question which arises in the light of this conclusion is, during the periods of time, were the claimants working? Of course, when they're working, they must be workers. You've got... It's the second part of 122, necessary to identify the periods during which the individual concerned is a worker employed under a worker's contract. And then at 123, do you see it says, 4 lines down, Uber contends that it was not open to the tribunal in law to make this... Sorry, I should start at the beginning. As mentioned earlier, the employment tribunal found that a driver was working under such a contract during any period when he, A, had the Uber app switched on, B, was within the territory in which he was authorised to use the app, and C, was ready and willing to accept trips. Uber contends that it was not open to the tribunal in law to make this finding, that the tribunal should have found that the claimants, on the assumption that they were only working under the workers' contracts during periods when they were actually driving passengers to their destinations. So that would be the equivalent of only when the referees are actually refereeing on a Saturday. Alternatively, Uber contends the tribunal should have found that a claimant was only working under such a contract from the moment when and not until he accepted a trip request. I think it clear, as did all the members of the Court of Appeal, including the dissenting judge, Lord Justice Underhill, if he was wrong on the main issue, that a driver enters into and is working under a contract with Uber London, whereby the driver undertakes to perform services for Uber London, if not before, then at the latest when he accepts a trip. So it's at the point of entering the contract on acceptance that the obligation to work personally arises. Then this: if the driver afterward cancels the trip, that signifies only that the obligation undertaken to pick up the passenger and carry the passenger to his or her destination is then terminated. It does not mean that no obligation was ever undertaken. And in my submission, that applies here directly, because what the tribunal has done, FTT has done, is it has said that no comparable obligation arises before the referee actually turns up, because he has a right, there is the right to terminate. But what that misses is that the obligation to officiate doesn't start when he arrives. It starts and is extant at the time that he enters into the contract. He undertakes to officiate, and that is the relevant obligation. And in my submission, what paragraph 124 is the application of the mutuality of obligation cases cited in paragraph 91 by Lord Legate.
It's a bit of an odd obligation, or a bit of an odd use of the word obligation to describe the situation where he can actually decide not to do it.
Can I take you to Lord Justice Lewis in Somerville in the next case, where he addresses this exact point?
Okay.
So can I then ask you to go to page 800? So, Somerville worker case, and it is a... It's the... this involves the... effectively a recorder, but a layperson sitting... a legally qualified person sitting as the chair of the Nursing and Midwifery Council Disciplinary Panel, ad hoc appointments. Question, was he a worker in relation to the individual engagements? Can I just try and take it quite quickly? Paragraph 23. At G, the claimant could and on occasions did refuse hearing dates, and the claimant could withdraw from a hearing even after it had been allocated to him without any need to provide a reason. The only requirement was that he notify the allocation team. He was not penalised if he withdrew from a hearing in this way. So there you've got on the workers, on the individual's part, a right to terminate at will. Then, can I ask you to look at 32? Do you see at 32, you've got the reason why the Employment Tribunal found that the individual contracts governing assignments were contracts but not contracts of employment was because of the ability to withdraw, and that appears from paragraph 213 of its reasons where it is said. And you see there they rely on the overarching contract case. And they also say at the end, it's a D of 802, but because the claimant could withdraw without sanction after the conclusion of the agreement and before the hearing, I conclude that there was insufficient mutuality of obligation to give rise to an employment relationship by reference to the individual assignment contracts. Paragraph 33, the Court of Appeal, Lord Justice Lewis, says, accordingly, the Employment Tribunal concluded that the claimant was not an employee, that is, he was not working under a contract of employment. There is no appeal against that finding, but then he goes on to say this. This reasoning is not, however, consistent with the subsequent decision of this court in Piedmont. And then it goes on to talk about what Lady Justice Lane said there. I should say Lady Justice Lane was, although she didn't give the judgment of the court in Somerville, she was on the panel in that case. Can I then ask you to look at paragraph 41? You'll see that the submission for the NMC, Ms Darwin, counsel for the NMC, said, Ms Darwin, for the respondent, submits that the contract cannot fall within the scope of Limb B of Regulation 2.1 of the regulations unless it includes an irreducible minimum obligation on the parties. And this is important because it's her definition of that irreducible minimum that they come back to deal with. That meant, submitted Miss Darwin, that each contract had to include an obligation on the part of the worker to perform some minimum amount of work. And then do you see at paragraph 42, it's elaborated further. Miss Darwin submitted that there were other features of the relationship that compelled the conclusion that there was no irreducible minimum obligation in this case. They included principally the following. She says, and the individual assignments had to be read together with the overarching contracts contained in the 2012 agreement and the 2016 agreement, and those did not oblige the council to offer or the claimant to perform any work. The claimant was entitled to refuse any individual assignment or to cancel it once accepted. Further, the reference to a person who undertakes to do work or perform services in Regulation 2 of the regulations carried with it the sense that there was an obligation on the person to do work or perform services personally. Then you'll see at paragraph 45, it said this. Having set out the definition of a worker, which you see at 44, so that's a Limb B worker, contract whereby so it's a contract, so importantly for a worker, you have to have any other contract, so it's a contract, and the other is obviously, A refers to a contract of service, so B, any other contract, whereby the individual undertakes to do or perform personally any work or services for another party to the contract. So that's the mirror of the RMC Limb 1 obligation on the employee. 45, that definition has within it a number of elements. First, there must be a contract. That is, there must be legally enforceable obligations owed by the parties. As Lord Justice Elias expressed in Quashi, every bilateral contract requires mutual obligations. They constitute the consideration from each party necessary to create the contract. Next, the contract must include a certain type of obligation. So far as the individual is concerned, if he is to be able to claim that he falls within Limb B of the definition of worker, The obligation must be one whereby the individual undertakes to do or perform any work or services and to do so personally. And then there's the second part, which isn't relevant for our purposes. So that's...
I might note that the definition in B, any other contracts, etc., it indicates that Parliament understands a contract of employment to be a contract of that kind, albeit there's some further. It won't be sufficient to make it a contract of employment, but that is a contract of employment is a contract of that kind.
Agreed. Yes, my Lord, I would adopt that submission, but I would say that's entirely consistent with also paragraph 24 of Windle in terms of Lord Justice Underhill's reasoning as to the relevance.
So the obligation to do the work personally is common to both Lim A and Lim B.
Yes. And just and also, but even the obligation on the employer to pay for work done, obviously it's not expressed there, but because there's a contract, there must be consideration. Well, that's what provides the consideration even in a Lim B case. But certainly as respect the worker, yes, expressly. Could I then please ask you to look at, so that was 45. Can I then ask you to look at 48, please? The Employment Tribunal also found that the claimant and the council entered into a series of individual contracts. Each time the council offered a hearing date and the claimant accepted it, he agreed to attend that hearing and the council agreed to pay him a fee. By those individual agreements and the obligations contained in the 2012 and 2016 agreement setting out how the claimant was to carry out the task of conducting hearing, the claimant agreed to provide his services personally. Those findings were sufficient to entitle the Employment Tribunal to conclude that the claimant was a worker in that he entered into and had worked under a contract whereby he undertook to perform services personally for the respondent, and the respondent was not a client of his business or professional undertaking. So that's notwithstanding the right to terminate. There is no need and no purpose served in seeking to introduce the concept of an irreducible minimum obligation, and in my submission the important words here are in the way defined by the respondent, and I've given you those paragraphs where you see the way defined. It's 42 and 43, which was in effect the overarching contract. Sorry, 41 and 42. Then do you see at 49? The conclusion is consistent with the decision of the Supreme Court in Uber. It's clear from the judgment that the drivers were not claiming to be providing services under any overarching contract between them and Uber. That would be inconsistent with the fact that the drivers were entitled to decide when, how, and how much to work. They were, however, providing services under individual contracts when they were working. And that appears from paragraphs 90 to 91 and 93 of the judgment of Lord Leggett. Then can I ask you to go to 51, please? '50 is a long... actually, sorry, can I just... Sorry, I was going to skip over 50. I'm not going to ask you to read them, but just to see that the paragraphs that are relied on are exactly the paragraphs I took you to from Uber 124. And you see at 50, Lord Justice Lewis makes the point, third line down. In that regard, Lord Leggett considered that at the latest the drivers were working under a contract when they accepted a trip, notwithstanding the fact that they could cancel it, so notwithstanding the right to terminate it. And that was the point I was deriving from paragraph 1-2.
Which paragraph were you reading from?
Sorry, apologies, my Lord. It's paragraph 50. It's page 50. It's page 808.
I see.
And it's
before the quotes.
C.
Thank you.
Apologies. In that regard.
Yes.
And so that's exactly the proposition that I was deriving from 124. And then can I ask you please to go to 52? So having cited a number of paragraphs. Sorry. And then it's 51 at C. 810, 810, C51. In other words, the parts of the judgment upon which the council rely are in a proper analysis concerned with the time at which a contract to work or personally to perform services arose. There was a contract to perform services personally when the driver was in fact working. As a minimum, such contract existed when a driver accepted a trip, and the fact that the driver could cancel the trip simply meant that the contract came to an end and did not mean that there had never been an obligation to provide services. And see para 124. Then do you see at paragraph 52, please? These paragraphs in the judgment in Uber therefore are directed towards identifying when the obligation to perform work arose. So that's exactly the point in our case. They are not intended to suggest that even where a person is working or providing services personally under a contract, there must be some superadded distinct obligation on a putative employer to provide work or an individual to accept work before that can fall within the scope of Limb B. 53, and again the crossover with the employment status cases. Similarly, other cases relied upon by the respondent, such as Nethermere and Carmichael, were concerned with whether overarching contracts were contracts of employment, so that the individuals were employed in periods when they were not in fact working. In that regard, it was necessary, you know that. They were not dealing with the individual contracts under which work was carried out, and do not impose any requirement that even when an individual is working or has worked under a contract of employment, that individual contract requires there to be some distinct superadded obligation to accept the work. And then you'll see they cite the analysis in Ijmal. Can I then please ask you 54? Can I just go to B, please, 811B? However, the fact that an overarching contract does not impose an obligation to work does not preclude a finding that the individual is a worker when he is in fact working. Quotes Uber Windle. The position is clearly established in relation to contracts of employment by the decision in the Ijmal case. And in my judgment, similar principles apply when considering the relationship between a general or overarching contract and individual contracts to do work or perform services personally. Quotes Lady Justice Lane. And then 55. Similarly, the fact that the claimant could withdraw from the agreement to attend a hearing, even after he had accepted it, does not alter matters. The claimant had entered into a contract which existed until terminated. So again, directly applicable to our case. Then 4 lines down, nor does the reference to, and lady, this I think addresses the point that your ladyship was asking me just before I went to Somerville, nor does the reference to undertakes indicate that there must be some distinct superadded obligation to provide services independent from the provision of the services on a particular occasion. Undertakes to do or perform in this context means no more than promises to do or perform. And of course the context is a contract. It is a contractual promise or undertaking. Finally, when deciding whether a specific agreement to provide services on one particular occasion amounts to a workers' contract, the fact that the parties are not obliged to offer or accept any future work is irrelevant. That's all I need to take you from Somerville, but what you have there in Somerville is exactly the issues that arise in our case, considered and addressed on a principled basis, entirely consistent with our case.
Well, I mean, necessarily, because our case bound the Court of Appeal in that case,
No,
isn't that right?
With respect, no.
No, you say not. Because it was a worker, a Limb B case. I see.
Exactly, and they did not treat themselves as being bound. What they do is use the Ijmal reasoning in support of their, as being consistent and in support of their own analysis.
Yeah. I mean, it was binding on them so far as contracts of employment were concerned.
Yeah, yes, but that's the point that Lord Justice Lewis makes, is that there was no appeal against the employment status finding, but he notes that it was inconsistent with Ijmal.
Thank you.
So undertakes to do or perform in this context means no more than promises to do or perform. And you'll note that his analysis is by reference to the established mutuality of obligation cases, Quashi, etc. My Lords, can I then go to the FTT decision? I have, and I have, I hope, addressed you almost on the actual decision by reference.
So you now, this is the third point in your first submission. This is the FTT's errors of law as you submit.
Yes, but as I say, hopefully I've identified in going through the authorities what the principal ones are.
Yes.
And, my Lords, my Lady, you will see that I do say that the upper tribunal erred because they adopted my learned friend's submissions, which were his primary submissions before you, that the mutuality of obligation, the content of the mutuality of obligation is the same as for both a overarching contract and an individual contract. And in my submission, that is simply unsustainable.
In that it has to include some promise to provide work or pay for it.
You have to provide the work or pay in lieu in the overarching contract. Sorry.
Can I just be clear where you, on the personal nature of the service, do you accept that on your test, the mutual obligation includes on the putative employee the obligation to provide the services personally?
And importantly, the FTT found as found.
Well, clearly they do here.
They made a very clear finding that that personal service question just simply didn't arise because it was obvious that the referees were being engaged to provide the service personally. They couldn't go and say, actually, I don't fancy doing it on Saturday. I'll get somebody else on the panel to do it for me.
Well, that's on the facts of this case. I think Lady Rose's question was more general as a point of law.
Essential. It's that third point.
Yeah, it's essential.
My Lord Stevens asked me to address Court of Appeal paragraph 122. I don't want to overlook it. And, my Lord, I do adopt, I do say that the Court of Appeal are correct there. What I do say also, though, is it's important to recognise that they are addressing the position as regards the issue that was before them, which was the RMC Lim 1 question. And you see that at paragraph 4. Do you see 4 lines down? The FTT also held that there was not either in the overarching contract or the individual contracts sufficient mutuality of obligation to satisfy the first of the 3 limbs of the RMC test. As I'll come on to show you, that's how this case has been argued.
But the point that I was making was that you've identified 2 errors in the FTT's decision, and I was just wondering whether they were replicated in the Court of Appeal's decision. You rely upon some level of mutuality, and you say it is the level of mutuality, and you rely upon paragraph 162. How does that read across to paragraph 122 of the Court of Appeal's judgment?
Yeah. So in my submission, when one looks at 122 and it's 5 lines down, The reference there to negated is, that's in the context of RMC Lim 1, it's a reference to the FTT finding that although there was some mutuality of obligation, it was insufficient for RMC Lim 1 purposes. And so therefore, it negated
And where does the FTT say that it negated the necessary mutuality of obligation?
In my submission, it's the word sufficient. So, and can I do that by reference to the decision, please? But as I say, that's the importance of it, of the argument being in the context of RMC Lim 1, because in RMC Lim 1, as my lords, my ladyship have explored, you either have it, the necessary irreducible minimum obligation, or you do not. And so therefore a finding that there was insufficient means that the necessary irreducible minimum obligation is not present, i.e. and it's the right of termination that the FTT rely on as negating the Lim 1 requirement being present, i.e. the sufficient mutuality of obligation. But can I show you...
But you accept that it comes in under Lim 3, treated with caution, and...
Yes, but Lord Stevens, with respect, where you've got it going both ways...
I appreciate that argument.
And there's no recognition of that here. But can I just show you the structure of the decision, though, please?
Before we leave 122, the penultimate line, immaterial.
Yes.
That's wrong, isn't it?
No, because it's being said in the context of the issue before them, which was Lim 1. It is immaterial to whether or not there is the necessary mutuality of obligation under Lim 1. That's the point. With respect, that's the point that Lady Justice Lane and the Court of Appeal are addressing there.
Yes, you say the last sentence you say is wholly consistent with the case law to which you refer this. Yeah.
And to which she refers as well, and relies on, because paragraph 68 is, she refers in 122 to the authorities in paragraph 68. One of those authorities, she refers to two, one of those is Stevenson. And that's paragraph 13, deals with this point in terms.
But if you're right, it seems rather odd that they then remitted this point to the...
So can I... I'm going to come on to the 174 and that, but well, can I just address your question now? Yeah. Now, Lady Justice Rose, in my submission, it's entirely consistent with the fact of the terms of the remittal, because if one looks at paragraph 4 of the Court of Appeal judgment, do you see the paragraph 4 identifies the scope of the appeal?
Are you looking at the order?
Sorry? No, I'm at the judgment, paragraph 4. I'll come on to the terms of the remittal, but I think in order to understand the terms of remittal, one has to see here what the scope of the issues were. What's the paragraph in our printed case? The FTT also held that there was not either in the overarching contract or in the individual contracts sufficient mutuality of obligation to satisfy the first of the three limbs of the RMT test. And then it goes on to deal with the second. FTT did not make a specific finding about whether the second limb was satisfied in the overarching contract, but did hold that it was not satisfied in relation to the individual contracts. HMRC appealed to the upper tribunal against those conclusions. And that was the battleground before the Court of Appeal. Did the FTT err in finding that RMC Limb 1 and 2, there wasn't sufficient mutuality and control for Limb 1 and Limb 2 purposes? And Limb 3 wasn't argued. And we addressed this in our printed case, para 44 of our printed case, where my learned friend accepted that if they did err, that Limb 3 they found for us. And that's why the Court of Appeal in paragraph 133 only remit the questions of sufficiency. If the issue had been before them, oh no, this wasn't a lim 1, lim 2 exercise.
So you're saying they only remit stage 3?
No, they don't. No, the contrary. Sorry, can I just finish so if the Court of Appeal, if the arguments before the Court of Appeal were no, this wasn't a lim 1, lim 2 exercise. This was the FTT were here carrying out the lim 3 exercise, then that would have been the issue that would have been remitted, or at the very least, it would also have been remitted back to the court, to the FTT. The fact it was not remitted, and the appellants took no issue with this. The appellants didn't say, no, this broad lim 3 also has to be remitted. Reflected the point that lim 3 wasn't an issue.
So, which page do I turn to find an acceptance that lim 3 was not an issue? You said there was an acceptance of that, as I
No, I
understood.
think one just has to.
Yeah.
So orally.
Sorry, orally.
Orally. So there's the exchanges, and that's how. But and as I say, it's in our printed case, paragraph 44.
44.
44 of our printed case.
But why does the issue of mutuality have to be remitted, if you're right?
So
I mean, if you're right, mutuality is straightforward. There's no questions there to be remitted, is there?
and I'm not asking you to remit that question, and because I do say that on the authorities cited by the Court of Appeal, that answer is dealt with. But if it is the balancing exercise, if the Court of Appeal considered this was the balancing exercise, it would not have been remitted in the terms it was. You wouldn't remit a lim, because you're not just looking at sufficiency of mutuality and control, you're looking at the whole, at that stage you're looking at the whole picture. And can I take you to the upper tribunal decision again to show you?
I mean, I just want to see what's going on here. In paragraph 133, they remit to consider, on the basis of the original findings of fact, whether there was sufficient mutuality of obligation and control.
Yes.
So in the individual contracts, there
Yes.
would be contracts of employment.
So,
And you neither party objected to that course of action,
no. Well,
because you were expressly given the opportunity of doing so here.
you see that there.
Yeah.
You see that there. And the reason we didn't object
Yeah.
is because that is lim 1 and lim 2. It's not lim, on any view, it can't be interpreted as remitting the lim 3 question.
But did the FTT ever consider lim 3? I'm not sure they did, because they knocked it out on the basis it failed with the necessary conditions.
Well, and
They
that's,
never really stood back and engaged in the overall evaluation, because they didn't have to.
yeah. And so when one, and that's perhaps the next point, is when one looks at the FTT
Well, then,
decision.
doesn't it follow that if they were wrong, that it should be remitted for them to do that?
Well, and if they, I think that's a point about, depending on the way the Supreme Court decides.
Yes, but one question.
How it is, but and I'm not now going to say, well, one has to obviously see the judgment. I don't want to get ahead of myself, but in terms of if you're asking about disposal,
Yes.
and it gets remitted, well, if Malone and Friend is not accepting that lim 3, the FTT found that lim 3 was satisfied, then it would have to go back. I would not be saying that you own. I'd have to take instructions, but subject to taking instructions, I would not be. Yeah, can I take instructions?
I think you do need to take instructions on what order you would, because if we dismiss the appeal, then this order stands. But it seems to me that on your argument, it's not the appropriate order.
But I say, in my submission, to understand why it was made.
Yeah, no, I understand why it was made, but that's neither here nor there.
That explains why. But could I just also, I'm just very conscious of the time. Lord Hodge, would you like me to stop now? Yeah, I'm just conscious of the time, 1 o'clock. I haven't quite finished 174. I haven't got to 174, but the meaning of... I don't know,
Is this a convenient time for you to break, or do you want to finish this point briefly?
Can I have 5... If I could have 5 minutes, I'm just conscious I've got a lot to get through on control. So if I...
Well, continue to... You were going to give us the FTT errors of law.
My Lord, can I pause on that? Can I come back at 2 and try and do it more
Come back at
precisely?
2 o'clock. Okay. Well, the court will now adjourn.